The ongoing litigation between Atiku Abubakar and Chicago State University, which Tinubu sought to join, and the judgment was delivered against him, eventually he appealed. Now the verdict has been delivered by Honorable Judge Nancy Maldonado. While making her ruling, apart from the reprimand, she made it clear she ordered Chicago State University to make sure they deliver all the documents that Atiku requested before noon on Monday, 2nd October 2023. Their oral deposition must be done before 5 p.m. the following day. On the reprimand, she told Tinubu that they will not entertain any further appeal, that it will be denied. Of course, he can go to a higher court, which is the 7th District Court, to appeal, but it doesn't look like he will get a stay of execution because of the timing. This is because, according to this latest ruling, by noon tomorrow, Atiku Abubakar will be in possession of Tinubu's academic records from Chicago State University. Looking at how swift the judgment was delivered, there's no way you can't envy the American justice system. No matter what you feel, no matter your reservations about what is going on in the United States, you can't help but give them thumbs up, because the judge was able to recognize the urgency of this matter. And if you look at the whole hearing, how she handled everything, you understand that there is a sense of judgment, understanding of everything. The deadline at the Supreme Court in Nigeria for submission of everything, all further evidence and replies, is on the 5th of October. So if that deadline passes, then all the effort that Atiku Abubakar has put in to the matter will be wasted. It was easy for the judge to make her decision, just like it was easy for Honorable Judge Gilbert at the lower court to make his own decision, because looking at the two certificates, it's obvious that this one is forged. Chicago State University attorney also accepted that they don't know where Tinubu got the certificate from. And looking at CSU's website, this is a form that a former student can fill out in case he wants a new certificate or diploma, like they call it. So one wonders, why didn't Tinubu fill out this form in order to receive a new certificate from Chicago State University? Meanwhile, during the proceedings at the Presidential Election Petition Tribunal, he filled this form. As you can see, look at the documents he requested Chicago State University to release to him so that he can tender in court to prove that he actually attended the school, which wasn't in contest anyway. One wonders why he didn't fill out the other form on their website in order to receive another certificate instead of downloading it from Pinterest. And looking at this form again, you can see that there is a checkbox for tuition records. Remember that Chicago State University said that they do not have any tuition records for Tinubu, that they do not have his international passport, that they do not have any information or record on how he paid for the tuition. So if they have this checkbox here, that means they must have the records. So why are they not releasing the records? Why is that of Tinubu different? So looking at all the controversies, you can see how easy it was for the judges involved to make their decision on the discovery. Also, Tinubu didn't help himself by arguing exactly the same thing on appeal. When one files appeal, it is expected that the person will focus on new information or mistakes on points of law from the judgment. But coming to appeal to make exactly the same arguments, the judge must have seen that this person is trying to hide evidence, unlike what happened at the appeal court in Nigeria, where the judges started making excuses on behalf of the respondents. INEC dodged subpoena. They even lied in court when they answered that one of the documents demanded by Labour Party wasn't available, that they do not have the document. In the end, their witness presented that same document that was requested under subpoena. All this happened in front of the judges. They didn't do anything. Instead, they started making excuses, manufacturing reasons for the respondents. Imagine saying that Shettima did not intentionally commit double nomination. This argument was never made by the respondents. How in the world did they manufacture a reason? Very strange. The relief sought by the petitioners is very strange. Instead, they upheld respondents, including manufacturing new ones for them. So saying that they were biased is an understatement. Many people thought that 25% is the surest that they must uphold because it is written in the law in black and white. But they ended up rewriting that section of the 1999 Constitution in order to arrive at a predetermined destination. It is very, very shameful. Nigerians can get justice abroad, but in their own country, they can only dream of it. Look at Ibori. If Ibori was tried in Nigeria, he wouldn't have been convicted. Maybe a judge would have boldly released him, but he was jailed abroad. This Atiku's case in Chicago, if it were to be in a Nigerian court, you already know what they will do. They will delay it unnecessarily. By the time they deliver judgment, it will be of no use. Justice delayed is justice denied, but that's not how it is applied in Nigeria. They will delay you into frustration. In fact, their attitudes borders on relegation of duty. They know that this is urgent, but they will not act. Look at all the litigations that many parties brought before the inauguration. They threw some of them away. Some judges ran away. They were not to be found. Do your job or you make way for another person to do the job. It's as simple as that. Why should judges be afraid of delivering judgment? Are they waiting for other parties to respond in kind? It's very strange how they operate.